tonight's session. And I will mute everyone, and in the event that you need to say something, just feel free to turn on your mic. Okay, so let's begin. I thank everyone for joining. I thank you for joining tonight's session. We have about 8 students today. And tonight we're devoting the tutorial session to foundation concepts of judicial review. But before we do that, I'd like to spend some time talking about happiness as part of the Happiness for Learning mini workshop. And in tonight's session, I will focus on gratitude and happiness. Now, before I do that, would there be anything that any of you might want to raise before I formally start the session? Any questions? Now, there will be 3 parts to tonight's session. We're going to have the Happiness for Learning mini workshop, which will run for about 10 minutes. Okay. And then I'll devote another 10 minutes for the drop-in session. So during the drop-in session, you can ask questions about administrative law, the concepts involved. You can ask questions about the assessments. And then we will begin the formal tutorial, which talks about the week for topic on time at 7. And then if you want to stay on, and if you need more time, I can extend the session after the 8 p.m. session ends. And we can devote a few more minutes for a drop-in session. So would any of you wish to raise any point before we proceed first with the Happiness for Learning mini workshop? We're good? Okay. So I've always had a fascination for happiness, mainly because as I pointed out in the first mini workshop we had for Happiness for Learning, it's different when you're actually happy doing something. And there is a study about this by Carol Dweck, for example, where she shows that when a person is happy, it actually broadens the mind. So when a person is unhappy, there are certain things that you don't see, that you don't observe. A lot of experiments have shown this. And so when you're happy, there's such a thing as the broadened theory of happiness, in the sense that you open up yourself to new things. You imagine more opportunities. You see the positive things in even the mundane activities. And so happiness is important, especially in the context of learning, because if you're unhappy, you're likely to miss out a few points. Whereas when you're happy, you're probably going to immerse yourself in the activity and are able to see better connections between or among concepts. So tonight, what we're going to do is to provide opportunities for you to critically reflect on the link between gratitude and happiness, and then critically reflect on your blessings and what you should be grateful for. Okay, so I've seen a comment from Gay. I'm going to go back to that Gay in a short while. Now, there is one of the researchers who's done a lot of research on happiness is actually a professor in the UK. His name is Professor Paul Dolan. And he talks about the idea that what you pay attention to is actually more important. More than how you are is actually what you pay attention to. And he likes the idea about the concept of the word pay, because it means you're actually expending energy, you're expending attention. And so, for example, some of you, I'm sure, have been through a lot of good things in your lives. It could have meant, you bought a new house, you found a new partner, a new boyfriend, a new girlfriend, good grades, probably, found a new career, better pay, and so on. Or you probably got promoted. And yet after a while, and this is borne by studies after studies, but after a while, the kind of happiness you felt in these external circumstances would have waned. They would have diminished. And it's like, the love you have for a person before, at the start, diminishes after a while. And that is because after a while, you begin to pay attention to new things. Would that be correct? So even if at a, even if you were to get a high distinction, let's say in administrative law, one term after, you would have forgotten the joy of having a high distinction. That is because you would have started to pay attention to something else. And worse, if you would have paid attention to something negative, which would then overwhelm, the positive experiences you previously had. On the other hand, the idea about paying attention is also good, because if you encounter, and a lot of us would have encountered negative events, it could be going through a divorce, going through a breakup, losing a job, losing a home, losing a family member. There is a point when even the pain of all these very negative and bad experiences diminishes. And that is, again, because, especially for those, there are some people who would say, after you've been through a trauma, after you've been something so negative, you should spend time being on your own, don't go to work. But actually for others, they felt that going back to work, trying to get back into the routine of things is actually helpful for them, because then they begin to pay attention to new things instead of dwelling on something that is negative. And so therefore, even if there is one certainty that we can have, even if we go through a trauma or something unfortunate, it is that at some point, the pain of the trauma will diminish. It may not fully go away, but it will certainly diminish. And that is because at some point, we need to pay attention to new stimuli. And part of it, therefore, is also the idea about adaptation. We begin to adapt to new things, and therefore, in a sense, we take for granted the things that have happened, the good things that have happened, and we take for granted, the negative events that we've come across. And so, therefore, one important strategy, therefore, in terms of trying to be happy, is to learn to pay attention to blessings. It may also mean paying attention to even past blessings. So for some of you, being in a relationship, and at some point you may feel that the relationship isn't fulfilling a need. If you begin to pay attention and dwell on the positive aspects of that relationship, you're likely to find happiness in the relationship. And so therefore, what I'd like you to do, probably just spend, a minute or two as an exercise, is for you to count your blessings, perhaps including doing your LLB. So I'd like us to spend a minute or two just being silent, just being reflective, and think about the blessings that are in your life. I know that, everybody has negative experiences. There's always misfortune in everybody's life, but perhaps there is something positive that is out there still. And I'd like you to pay attention to the good things that are happening in your life. It could be about having kids. It could be about the fact that you're able to do an LLB. It could be about the fact that you are in a relationship, you have a loving family, you probably even have a dog, or, all those things. So let's spend 1 or 2, probably 2 minutes. Count your blessings, and if you could, write it down. If you could identify 3 or 5 blessings. Keep that in your notebook, and actually, every day, what you should be doing is to start counting your blessings every day. It shouldn't take more than a minute. I am blessed because 1, 2, 3, 4, 5. You do that every day, and I bet you, based on studies, you will feel better. So can we do that for 1 to 2 minutes? Count your blessings. If you like, you're free to post some of your blessings if you're happy to share it with the rest of the class. Because I've seen some of you sharing your blessings in the chat box. So feel free if you want to. Very good. So I'm going to have to end the session there because we need to move on. But try to remember the importance of paying attention to your blessings. Silent, not good at that. Okay. I'm reading that from Gay. That's right. Indeed. Yeah. Even the idea of brushing your teeth and feeling the satisfaction of being able to do that can count as a blessing. That's very good. So I hope you make it a habit to count your blessings, because after a while, what was fantastic before loses its appeal. So we might need to refocus our attention on those that can bring us happiness. Now, there was a point made by, and I'd like to address this briefly. There was a point made by Gay about her being optimistic and resilient and not necessarily being happy. So when I speak of happiness, and this is the way that other scholars would refer to it, happiness can be used as an umbrella term for a lot of very positive emotions. So happiness can be joy. It can be the sense of amusement. It can be the sense of optimism, the sense of resilience. So anything, so when we speak of happiness, it's just having those positive feelings and positive experiences. Okay, so very good. Okay, so we'll end that for tonight. I actually had a question which I posted on Facebook, and that was whether or not we should continue to have the Happiness for Learning sessions, given the fact that our time can be limited. So if we were to have extra time, apart from the 7 to 8 weekly tutorial that we have, I was hoping to do more drop-in sessions where you can ask questions about concepts pertaining to administrative law. It could be questions about assessments and so on. So we have those extra sessions, which we call drop-in sessions. I did this in constitutional law, and I think it was very helpful. It could be that we use those drop-in sessions to build skills on like how to identify a legal issue of a case problem. It could be to spend time on how to do a good case note. Now, so given the fact that we could devote these extra minutes for things that directly relate to administrative law, and perhaps passing the course or doing well, the other question, therefore, is should we spend time on Happiness for Learning, the Happiness for Learning mini workshop? So Rob says a vote to keep them. So you'd like us to keep the mini Happiness for Learning mini session? Because my concern is, some students would feel like this seems to be too extraneous to administrative law. What are we doing? But then again, it's not just about doing something, right? The attitude matters a lot, don't you think? So in other words, if you're not in a proper emotional state, you're probably not going to enjoy what you're doing. Okay, good. So we can keep them. And so what we're going to do is, what I'm thinking is that in the future, I think starting in week 5, we will start earlier. Perhaps we could probably start at 6:40 and see how it goes. So that we do a 10-minute mini workshop on Happiness for Learning, then another 10 minutes for the drop-in session. Now, if it happens that students need to spend more time asking about administrative law, then we could probably begin at 6:30. So that in that case, we have 10 minutes for the Happiness for Learning mini workshop. Then we devote another 20 minutes to a drop-in session. And then we still have our 1 hour for the weekly tutorial. Because what we need to remember is that starting in week 5, after 8 o'clock, we're going to be devoting that time to the student presentations pertaining to the case note. Okay, very good. Thank you, Leonie, for the feedback. So, any questions so far on anything? What we've covered, what we might cover, and so on? So we're having a drop-in session now. You could ask questions about the assessments and so on. I think I remember on Facebook that there were some who wanted to ask a question about quiz 2. And I wasn't too sure what the question was about. So
yeah, Manjo, it's Emma.
Emma, yes.
Can you just explain the answer to quiz 2 again? I'm still quite confused.
You'd like me to post the answer to quiz 2? Is that it?
Can you just explain how the answer to quiz 2 came about? Because I'm still quite confused. I thought you could go to a merit review for an executive decision. So I'm a bit confused. And maybe it's because I did constitutional law last year and last term, and that's confused me. But I'm a bit confused.
So you were saying that you were wondering why you can't have a merit review.
Yeah, that's right. Why can't you go to a merit review for an executive?
Okay, very good. Okay.
Does that make sense?
That it does.
Yeah.
Can you just give me a minute? Somebody's knocking on the door, if that's all right. It's probably my son. I'll come back. Hang on. I will be very quick. Okay, thank you for that. So the reason is, in a sense, actually simple. So as far as merit review by the Administrative Appeals Tribunal is concerned, there are two requirements, among others. And we're talking about jurisdiction. The first is that the administrative decision must have been made under an enactment. So when you speak of an enactment, then it is at least based on a law that is passed by the Commonwealth Parliament, or a statute, or an instrument. So are we clear so far? So that's the first jurisdictional requirement. So it has to be based on a law passed by the Commonwealth Parliament, which suggests that if the administrative decision is based on the exercise of an executive power, the administrative decision, therefore, was not based on an enactment. So let me repeat. A requirement for there to be merit review by the AAT is that the administrative decision must be made under an enactment. So you can only have an enactment if it is based on a statute passed by the Commonwealth Parliament. So that is the requirement. So in other words, if the administrative decision is based on the exercise of the executive power, such as the prerogative power or what is known as discretionary power, then in that case, it is not based on an enactment. So what we need to remember is that as far as the executive is concerned, it has certain powers which do not rest on an enactment coming from the Parliament. It doesn't, for the executive to act, it does not always require authorization from the executive. Number one, remember that under Section 61 of the Australian Commonwealth Constitution, the executive has certain executive powers, the power to execute and maintain laws of the Commonwealth. So in that case, the power of the executive does not rest on parliamentary authorization, meaning not from a statute. It comes from Section 61 itself of the Constitution. Secondly, we have what is known as prerogative powers, and these are powers recognized by the courts as inhering in the executive, even in the absence of a constitution, even in the absence of parliamentary authorization. So for example, in the UK and in New Zealand, there is no constitution. But it cannot be argued that the executive has no executive power simply because there is no written constitution. So the courts recognize that the executive has certain powers, certain executive powers, even outside the constitution and even outside parliamentary authorizations. For example, the power to pardon criminals, the power to enter into treaties, the power to declare war, the power to enter into contracts, the power to create certain agencies within the executive. These are executive powers which can, of course, be exercised by the executive, even in the absence of parliamentary authorization in the form of a statute, which means, therefore, that if there is an administrative decision and the administrative decision is based on the exercise of executive powers and not based on an enactment, then you cannot have merit review by the AAT. And there is a second reason for that. And then I'll go back to you, Rob, in a short while. Okay? So there's a second requirement as far as merit review by the AAT is concerned. So not only must the administrative decision be made under an enactment, but that particular enactment or that statute passed by the Commonwealth Parliament must itself provide that merit review is available with the Administrative Appeals Tribunal. So those are the twin jurisdictional requirements. There is an administrative decision made under an enactment, and that same enactment must provide for merit review by the AAT. So if you try to connect this to judicial review, under the Administrative Decisions Judicial Review Act of 1977 Commonwealth, judicial review is available when an administrative decision is made under an enactment, right? As far as merits review is concerned, however, it is insufficient that the administrative decision is based under an enactment. It is also a requirement that that same enactment provides for review by the AAT. Okay, Rob, you have a question? Oh, the vacation week. Okay, I was thinking it was going to be about the concept. So next week is going to be the midterm break following the calendar of the university. So we have a break. We don't have a class next week in the entire university. I've actually also changed the Moodle site so that week 5 happens after the midterm break. But if you look at the unit profile, after week 4 is actually the midterm break. Okay, questions on what I've explained so far?
Yeah, I've got a question, Manjo, and it could be also a bit of a statement. I understand that for a decision to be reviewable, it needs to be under an enactment, and it also needs to be in that enactment that it's reviewable by the AAT. I understand that, but the answers stated, with the wording that it was not reviewable because it was made under an executive power. Okay, which now I understand, but at the time I wouldn't have guessed that in a million years because I didn't link not under an enactment and executive power not being in an executive power to be meaning the same thing. Right. So it's just a language thing. So I was what I said on Facebook was more of a statement is about being consistent with language.
Okay.
And I didn't recognise that as meaning the same thing. You know where I'm going at?
I see your point.
Yep.
The thing though, and so you're in a sense your observation is valid. The thing though is that when you speak of executive power, there are at least 3 sources of executive power. So we have the Constitution in Australia, which is Section 61. 2, we have prerogative or inherent powers recognized by the courts. And 3, therefore, we have statutes passed by the Commonwealth Parliament. So there are 3 sources of executive power. So when we speak of the exercise of executive power, we cannot assume straight away that it is based on a statutory enactment because there are 2 other sources of executive power. So in other words, whilst it can be said that a statute passed by the Commonwealth Parliament is a source of executive power, the reverse is not true. We cannot say that executive power is necessarily equivalent to a statute authorizing the Commonwealth Parliament to exercise certain powers. So executive power is broader. The enactment necessarily is limited and confined to those instances when a statute is passed by the Commonwealth Parliament.
Yep. Yeah, I understand that. Also, in the facts, there was nothing to represent that it was under an enactment, which I understand as well.
Yeah.
But the answers didn't reflect anything that I recognised. So because I thought it was more an employment decision, where the decision was made based under employment. So I didn't click that as an executive power. Do you understand?
I think
so. You're saying it wasn't available because it was based on an executive power.
Yes.
Where an employment decision is that really in an executive power?
Okay. So I see what you mean. So for example, the power to appoint and the power to terminate invokes the exercise of executive power. We agree on that, right? The question is, what was the source of the executive power? So the question is, was it based on Section 61? Was it based on prerogative powers? Or was it based on a statute passed by the Commonwealth Parliament? Nothing in the question indicated that the hiring and the termination decision was based on a statute.
Correct.
It wasn't there in the facts.
Yep, I agree.
We know that the executive power was exercised because there was, hiring and then there was a firing. So because we cannot assume, it's not there, that it was based on an enactment.
Yeah.
We must assume, therefore, that it was simply based on the exercise of an executive power, not founded on a statute or an enactment.
Yeah, I think it would have been more based on it was an employment contract decision, not an executive decision.
Oh, hang on. Let's clarify that. Assuming that there was obviously an employment relationship between the department and that guy there. I can't remember his name.
Yeah, I can't remember it either.
So there was definitely an employment contract. No doubt about that. But
yeah.
the question is, the power exercised by the executive in terminating the employment, I think, of Goodwin, what was the source of that power? That was the question. In fact, if you raise it to a higher level, the power to hire Goodwin in the first place, what was that based on? Was that necessarily based on a statute? Or could yeah?
There's no facts to say either way.
Exactly, that's the point. So because it's not in the facts that it was based on a statute, but we know that there was an exercise of executive power, we must assume that it has to be the exercise of the executive power not based on statute, but on some other aspects of the executive power.
Yeah, I understand that. So for the purposes, just so we cut this off, is for the purposes of this subject, if it's not based on an enactment and executive power comes up and there's no facts to point it in either direction, we say that it was an executive power.
Yes.
Okay.
You cannot assume that it was based on an enactment because that is the requirement.
Yep, I get that.
That is the requirement. For as far as merits review, there is a requirement. There must be an enactment, and the enactment must provide for merits review.
Yeah, I'm just trying to break it down so I fully understand it.
Yeah. So,
Manjo.
Yes. Who's that?
Just Jesse, just quickly. I also chose the wrong answer. I selected B. All the answers were wrong. I formed the view that he could apply for a merit review based because the decision of the minister was based on an exercise of power. I assumed, and I researched and found the Public Service Act, where it discusses that the executive can terminate employees under the Public Service Act. So I thought he could apply for a review under an enactment.
Okay, that was the other thing. You have got to limit your answers when you provide an answer. Let's say for the final examination, limit yourselves to the facts that are there, and I don't want you to be chasing. I think Monique Tudman asked this question, I think in the forum posts, and they said you cannot refer to any other law. So we don't want to examine the Public Service Act, for example. We base it on the facts which are provided in the assessment. Okay, now we could go back to this. In the meantime, it's 7. I recognize the time. I'd like to proceed with the tutorial on foundation concepts of judicial review, and then we can go back. So just as a reminder, when it comes to the quizzes, as well as to the final examination, you need to limit yourselves to the facts that are there. You also limit yourselves to the law as stated in the facts. So don't look for, particular law. So for example, if I say under Section 29 of the Migration Act of 1979 Commonwealth, don't look at that particular law because in fact, a lot of the factual scenarios there and the provisions even are likely to be hypothetical. I'm just providing a context. Okay?
Manjo,
yes? Lois.
Manjo, it's Lois.
Yes.
I think, like for me, I think the questions are written in a bit of a, I'm trying to think of the right word, like a bit of a complex or kind of tricky, twisted way. And I guess for me, that's really a concern that I have for the final exam, especially being invigilated. Like, I don't think, especially bringing in those acts that we're not allowed to look at. I think, especially in examination, or even in this case with the quiz, because we're all trying to get the mark. to go towards our final mark, it kind of it plays with your mind a bit. If that, I don't know if I'm wording that right.
So perhaps, for example, in relation to quiz 2, I should have said, if I follow you, I should have said that this was based on the exercise of prerogative power and was not based on a statute passed by the Commonwealth Parliament, something to that effect. Is that it?
Yeah. Look, maybe that might be it, but yeah, I mean,
my other concern really is that if I were to provide so much information, but my concern is like I might end up giving away the answer.
I guess my concern is that the final examination questions are going to be that tricky. Whereas, like, I know in other subjects, the like the invigilated questions for an invigilated exam may seem a little bit more tame than if it was a take-home paper, because you're under more pressure and you don't have as long to look at it. Okay,
I see what you mean. So I'm actually in the process of making the writing the final examination for this unit, because I think it has to be submitted by the 16th of December. I will certainly take on board what you said and make sure that I avoid instances which can make it really confusing for students. And I'll also be very explicit when saying, ignore having to read this particular law. So I'll make those guidelines as well.
Great, thank you.
Okay, so let's proceed. What we're going to do, so at this point, we'll move on to our weekly tutorial, week 4 tutorial on foundation concepts of judicial review. And you'll probably notice that weeks 4 to until week 10, the topics revolve around judicial review, because the notion of judicial review can actually get really complicated. And so what we will be hoping to discuss and explain tonight after studying this topic is that you have a better understanding of the concept of legality in judicial review. The notion of legality appears simple, right? What is legal? But as we see later on, it can get tricky. So does it mean that if we speak about legality, if it's a factual question, then necessarily it doesn't involve legality? Or when we speak of the exercise of discretion, does it mean therefore that that does not involve legality? So these are some of the questions that we will be encountering when we speak of judicial review. And in particular, I'm conscious of the comments here, and we're going to respond them in a short while, okay? Because otherwise I'll get sidetracked. So I'll get back to this in a short while. And after studying this topic, you should be able to discuss and explain when an administrative decision is unlawful or contrary to law, and then the grounds for judicial review of administrative decisions under common law and under the Administrative Decisions Judicial Review Act, 1977. So, before I continue, would there be any questions so far? Comments? None? We're good? Okay. So why don't we begin by dealing with discussion question 1. Can I have a volunteer, please? Just to read the discussion question.
I'll volunteer for that, Manjo.
Yes.
Okay. Sheldon Wang applied for the Family Tax Benefit, FBT, with the Department of Human Services, DHS, on the 15th of March 2015, a day after he was granted an Australian permanent residence visa. The new A-Tax System Family Assistance Act 1999 Commonwealth provides that an Australian permanent resident with, sorry, I can't quite get the side of this. Hang on.
Hang on, is it my problem with the way I've shown it?
Permanent resident.
Wait, are you able to see my screen?
Who has an FBT child who Wang has is entitled to the FBT. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for the FBT only if she has held that permanent resident status for at least 1 year. On account of the Minister's new regulation, the application of Wang for the FBT was denied. Wang's repeated request to the Minister's delegate to reconsider the DHS decision was denied. Wang has approached you as a solicitor for legal advice. He is thinking of asking the courts to review the administrative decision. In particular, he would like the courts to set aside the DHS administrative decision and order the DHS to grant him the FTB. Is the court likely to grant the remedies sought by Wang?
Thank you, Peter. Now, let me just point out something here, because I think we had this particular question in the last tutorial for the purpose of identifying the legal issue. Note that the question here is specific. Is a court likely to grant the remedy sought by Wang? So in other words, as far as this particular discussion question is concerned, the focus of our question is not so much whether or not judicial review is available and whether or not, what the jurisdictional grounds are available. We have a more specific question. And the legal issue is a court likely to grant the remedy sought by Wang? So that's the focus, okay? Okay, so can somebody care to provide an answer to the question?
I'll have a go, Manjo.
Anthony, yes, go ahead, Anthony.
Well, I think it's unlikely that they'll grant the remedies, and the reason is that judicial review is limited to probably just lead to a quashal of the decision, which that is contrary to law. I think the court would have no power to grant the DHS, even if the decision was contrary. Yeah, so it's unlikely.
Very good. Other comments? Other answers?
Would there be an avenue under common law failure to provide fair treatment?
Who's saying this? Jesse?
Yeah.
Okay, so in relation to the question of Jesse, the thing about the common law is that the judicial remedies are also quite limited. So for example, and we're gonna get to this later on, there are very specific judicial review remedies such as prohibition, mandamus, or injunction, or certiorari, or declaration. So these are some of the judicial review remedies. So in other words, it is one thing for there to be a possibility for judicial review. The other question you really ask is, would it be effectual to actually seek judicial review? And so, for example, if you speak about, and this is something we're discussing, I think, in week 10, for example, if you speak about the judicial review remedy pertaining to the issuance of a writ of prohibition or the issuance of the writ of injunction, which is to restrain a decision maker from undertaking particular action, there are certain jurisdictional facts that have to be met. And one of them is that the decision maker, for example, needs to act judicially. And we will learn later on when we discuss, I think in week 6, the idea of natural justice, that the idea that a decision maker must act judicially requires two things. One is that the decision maker is required to provide a person who might be aggrieved or affected by a decision the opportunity to be heard. And the second requirement is that the decision maker must be free from bias. And we will later on see that it is not often the case that there is a requirement to observe the requirements of natural justice. Okay, we will later on see. So I raised that point, therefore, because the whole purpose of the Administrative Decisions Judicial Review Act of 1977 Commonwealth is actually to address the constraints of the common law judicial review remedies. So because there are specific, as we will see later on in week 10, the attempt to seek judicial review remedies under the common law can be quite complicated. In fact, we will see later on in week 10 that the common law can be very rigid and restrictive. So these, for example, certain requirements must be met in order for the common law remedies to be available. And there is also the aspect of prerogative remedies available in the courts, which enables the courts to act in an equitable manner. But again, there are certain jurisdictional requirements that need to be met. And because of the difficulties by which litigants who could have availed of judicial review were stymied from seeking judicial review remedies, this is the reason why the Commonwealth Parliament decided to pass the Administrative Decisions Judicial Review Act of 1977 Commonwealth, because one, in a sense, it has codified the grounds for judicial review, but at the same time, it has actually provided more powers to the Federal Circuit Court as well as the Federal Court of Australia in relation to the powers that it can undertake or exercise in order to cure decisions made by the administrative decision maker when the decision is unlawful or contrary to law. So we look at, therefore, common law judicial review remedies as a last resort. So when you're faced with a situation, and so this is as far as the final examination, for example, is concerned. When you're faced with a situation where you're asked as a solicitor to provide advice on judicial review remedies, the first question you ask always is, would judicial review be available under the judicial review, under the Administrative Decisions Judicial Review Act of 1977 Commonwealth? That's the first question you need to ask. And we will recall that the ADJR Act 1977 Commonwealth is available when the administrative decision is made under an enactment. Okay, now, if that is not available, then you next consider Section 75 of the Commonwealth Constitution, which gives to the High Court the original jurisdiction to issue writs of prohibition, mandamus, and injunction against officers of the Commonwealth. Now, there is also a statutory, so that is a constitutional writ because it comes from the Constitution. So in other words, the Commonwealth Parliament cannot divest the Commonwealth or the High Court of its original jurisdiction. There is a counterpart in Section 39B of the Judiciary Act of 1903 Commonwealth, which provides the Federal Court of Australia the same power to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth. So barring the availability of the judicial review under the ADJR Act of 1977 Commonwealth, or Section 75(5) of the Australian Commonwealth Constitution, or Section 39B of the Judiciary Act of 1903, then you examine the possibility of judicial review being available under common law. Okay? Now, what we need to remember is that if you examine the first three sources of judicial review, one is based on statute, based on the Commonwealth Parliament, right? The second is, which is the Commonwealth Constitution. It's based on the Constitution, so there is a constitutional basis. The third source is again statutory because that's the Judiciary Act of 1903. But the fourth source of judicial review is what is known as common law judicial review. It has nothing to do with the Constitution, nothing to do with the exercise of the Parliament of its power, but the exercise by the courts of what they perceive to be their inherent power to police the exercise by the executive of its executive powers. And we see this, for example, in the case of Entick versus Carrington, which I think we're going to see in week 5. So are we clear about the steps for us to examine whether or not we should be exploring judicial review? ADJR Act, and then we examine at the same time Section 75(5) of the Commonwealth Constitution and Section 39B of the Judiciary Act of 1903, and then we examine common law judicial review remedies. Okay, questions? Did that answer your question, Jesse?
Yes, it did. Thanks. So just to be clear, in the examination, you'd expect us to be working through the problem and plead alternatives, starting at the ADJR, and then plead in the alternative, the Constitution, then the JR Act, and then the common law?
my suggestion is, if you could already answer the question by just referring to the ADGR Act, you stop there. Create a document. Okay. Just try to remember, Dakota, what I suggested. If I could, I'm going to write it down, but otherwise, just remember the steps. So going back to the question of Jesse, in a final examination, the first question that needs to be asked is judicial review available under the ADGR Act of 1977 Commonwealth? If it is, you end there. You stop there. Are we clear? There is no point. That's exactly the reason why you have the ADGR Act, to simplify things. So there's no point in examining Section 75.5. And remember, Section 75.5 of the Constitution is difficult because it relates to the High Court. The High Court is unlikely to accept it's not going to accept just any application for judicial review. It has to be of national significance. And same thing with the other problem with the Judiciary Act of 1903 Commonwealth, which is Section 39B, is that the remedies are limited to the writs of prohibition, mandamus, and injunction. And we will see later on that there are certain judicial requirements, jurisdictional requirements that have to be met before these writs can be granted. So if the question can be answered by reference to the ADGR Act of 1977 Commonwealth, we stop there. Okay? Now, let's continue. Now, so in this example, what grounds are the basis for the judicial review? Very good question. Gay, what was the ground here? What is the ground for review of the review of the judicial decision? What is the ground for the judicial review of the administrative decision? Gay is asking that question. Very good question, Gay. Any volunteers?
The legality of the minister's decision.
Okay, well, why might it be potentially illegal, Peter?
Because of the because he is overriding what is in the actual act, which was passed by Parliament. He's just made an arbitrary executive decision.
Very good. That's the ground for the judicial review. So the regulation of the minister, as pointed out by Peter correctly, is contrary to the act passed by the Commonwealth Parliament. So what we need to remember is that any regulation passed by the executive on the basis of a primary legislation or a law passed by the Commonwealth Parliament is what is known as subordinate legislation. The subordinate legislation cannot override the primary legislation. So if the subordinate legislation is contrary to the primary legislation, then that subordinate legislation or the regulations of the minister would be unlawful. That is the ground for judicial review. Well done. Now,
Manjo?
Yes, Jesse. Go on. Or was it Anthony?
Yeah, sorry, it's Anthony. Okay, in regards to jurisdiction, it will state in the act or the regulation who has jurisdiction to actually hear that matter then?
Sorry, can you repeat that for me, please?
Yeah, sorry. In the actual act or the regulation, it would state in there who has jurisdiction under one of the provisions. Is that where you get that? No?
Oh, no. Because the moment an administrative decision is made under an enactment, that's it. If a decision is unlawful or contrary to law, then the fact alone that the administrative decision is made under enactment already is the jurisdictional basis for judicial review. That supplies the jurisdictional basis. There is no requirement that that particular enactment would say that there is jurisdiction by the courts. It is the Administrative Decisions Judicial Review Act which provides the jurisdictional basis for the exercise by the federal court or the federal circuit court of its powers of judicial review. Compare this to merits review. The enactment must provide for merits review by the AAT. That's the merits review. As far as judicial review is concerned, the basis of judicial review is actually the ADGR Act itself, because it says that when an administrative decision is made under an enactment, then the Federal Court of Australia or the Federal Circuit Court of Australia has jurisdiction over applicant for judicial review. Now, I'd like to go back to the answer to this one because I'd like to reiterate this. So I think it was Anthony who said earlier that the court is unlikely to set aside the DHS administrative decision and order the DHS to grant him the FTB. I want to focus on that aspect where the court cannot order the DHS to grant the FTB. I want to focus on that. Give me a second. Okay, this is very crucial here. So having said that point, what have we learned from the previous discussion question? That point about the fact that a court is unlikely to order the DHS to grant him the FTB. What is the significance of that?
So they can only recommend either a review or a writ of mandamus or the like.
Mm-hmm.
A review of the original decision, or if need be, a writ of mandamus.
They can only return that to the original decision maker, but having made the decision that the original decision maker's decision his ruling was the minister's ruling was illegal, that then becomes it becomes a different ball game altogether, because the original decision maker then has to look at that decision in light of what the legality of the act is.
Okay, good. Now look at this from the viewpoint of being the solicitor. Okay, imagine that you're the solicitor, and you know that, for example, based on Green versus Daniels, assuming even that the court agrees that the decision is wrong, that the administrative decision is wrong for being contrary to the law or is unlawful, and yet the court cannot order the decision maker to act in a particular way. If you're the solicitor, what is the significance of that idea, of that limitation of judicial review? Think about it. So you know that the court will accept that it has the power of judicial review. You know as well that the court is likely to say that the administrative decision is unlawful and contrary to law. But the court will stop short of ordering the decision maker to act in a certain way. If you were the lawyer, think about that. What is the significance of that?
Well, other than the frustration, you would ask for a writ of mandamus. You would say that this is therefore your duty, and you have to perform your duty.
Okay, thank you, Carl. I'm going to go back to the idea of mandamus in a short while. How about the others? Try to think of the significance there. If you're the solicitor, you know that even if judicial review is available, the court will not order the decision maker to act in a particular way. What does that suggest to you?
I'm just going to go out on a limb, Manjo, and try to take my mind back to what I tried to read this week, where they said that there was like a very limited set of circumstances where merit and judicial review crossed paths, and I need to somebody jump in and save me while I flick through notes.
Okay.
Is this where the unreasonable
Not yet. We're
come
not
in?
here.
No?
No.
What did it say? There was like a situation where judicial review can, like, it can sort of cross paths. Is that where you're going with this?
No. I'm talking about the effectiveness, the effectuality of judicial review.
Oh, well, in that case, it doesn't matter that it's contrary to law. They still can't substitute the decision.
Yeah, did you see the point there? The court agrees with you, you're right. You should get this. But I can't do anything. You know what I mean?
Manjo, I think the thing is with this is, even though the court will not or cannot substitute the decision, by making that illegal, that decision, or the legality of the minister's rules and regulations, bringing that then forces it back to be brought in, to be looked at under the correct rules which have been which are enacted.
Fantastic, Peter. So I kind of missed that. You're right. So we know now that the limitation of judicial review is that it is unlikely to order the decision maker to act in a certain way. It can quash the decision, but it cannot order the decision maker to act in a certain way. And this is the case of Green versus Daniels. But as Peter pointed out, the fact alone that the court will not order the decision maker to act in a certain way doesn't mean that judicial review is ineffective or ineffectual, because if the court strikes down or quashes the administrative decision, then it will force the administrative decision maker to act, in a sense, in accord with what is lawful as found by the court. So it's not totally ineffectual, only partly ineffectual, but there is still that value in law, because the decision maker will be confronted with a ruling from a court saying that what you did was unlawful. But in terms of what the specific action is, that is left to the decision maker to do. So the other crucial point there is that as far as judicial review is concerned, the courts will not substitute its own decision for that of the decision maker. So you contrast this, or you compare this to merits review, where in merits review, the tribunal actually steps in the shoes of the original decision maker and will substitute its own decision for that of the original decision maker. In judicial review, that will not happen. The courts cannot substitute its own decision for that of the original decision maker. So are we clear? So what is the importance of the case of Green versus Daniels to administrative law, particularly in relation to the availability of remedies available in judicial review? So the importance of the case of Green versus Daniels is that even whilst the court may agree that the administrative decision made an unlawful decision, it is unlikely to grant the specific remedies sought by an applicant for the decision maker to act in a particular way, such as, for the decision maker to grant certain benefits. But it will be effectual in the sense that if the court, in its exercise of judicial review, finds that the administrative decision is contrary to law, at least it will quash the administrative decision and therefore provide directions to the administrative decision maker to make a decision on the basis of what is lawful. Okay, so I raise this reflective question because that is the way I would like you to approach, as far as the case notes is concerned, on what is the importance of the case you're working on in relation to administrative law. Okay, clear so far? We're good. So let's proceed to discussion question 2. Okay, can I get a volunteer to read discussion question 2 for us? And then we're going to that issue about unreasonableness actually in discussion question 3, because I prepared another question there. Can we have a volunteer to read question 2? Just to read the question. Volunteers?
I'll jump in and get it done.
Take her up.
Sheldon Wang applied for the Family Tax Benefit, FTB, with the Department of Human Services, DHS, on the 15th of March 2015, a day after he was granted Australian Permanent Residence Visa. A new tax system, Family Assistance Act 1999, Commonwealth, provides that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the FTB. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for the FTB only if he or she has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated requests for the Minister's delegate to reconsider the DHS's decision was denied. Wang has approached you as a solicitor for legal advice. What legal steps would you suggest and why?
Thank you. So this question is broader compared to the first, because the first, in relation to the first discussion question, the specific question was, is a court likely to grant the remedy sought by Wang? So look at the assessment task that is asked. here, the question is, what legal steps would you suggest as a solicitor and why? Any volunteers?
My first legal step would be a judicial review on this.
Go on.
And the reason being, the way that the law, the Act provides for an Australian permanent resident who has an FBT child automatically gets that. Once that minister's decision would overturned.
Very good. Now, it was a bit too broad, Peter, when you said that you would consider applying for judicial review. What type of judicial review? I mean, what's the basis for the judicial review? Remember,
on the legality of the minister.
I meant, are we speaking of under the ADGR Act? Is it judicial review under Section 75(5) of the Constitution?
No,
Okay.
It would be under the Act.
Under the Administrative Decisions Judicial Review Act.
Yeah. On the basis of the legality of the minister's regulation.
Okay. What is the crucial requirement for a court, for a federal court, to have jurisdiction over an administrative decision under the ADJR Act of 1977? What is the requirement there? That is, administrative decision must be.
It has to be under an enactment.
Very good. So there's that requirement. The question then is, the decision here was not made under the Commonwealth Act. It was made on the basis of new regulations. Would the new regulations of the minister be covered under the concept of enactment?
No, they wouldn't. But the original decision is under an enactment.
Okay, but the decision here is not based on the statute passed by the Commonwealth Parliament. The decision is based on the regulations made by the minister. So the question here is, as far as the ADJR Act is concerned, would the regulations be considered enactment in order to vest jurisdiction in the federal court?
No, that'd be minister's prerogative. That'd be an executive prerogative.
Okay.
Can I jump in here, Manjo?
Yeah, who's that?
Yeah, it's Anthony.
Anthony, go ahead.
I'd say it's deemed an instrument under Section 3(1)(c).
Very good. That is the correct answer there. So as far as Section 3(1)(c) of the ADGR Act is concerned, that would be considered an instrument. So an instrument is a document made under an act. So in other words, it's in the context, as far as in the context of the Judicial Review Act of 1977 is concerned, if the instrument is made in pursuance of under the authority of a statute, that is considered an enactment and is covered under Section 3(1)(c) of the ADJR Act. So it is not just the primary legislation itself. An instrument made under the primary legislation is also covered under the notion of enactment. So very good. So if you were to be the solicitor, you would suggest that Wang apply for judicial review, and as pointed out by Peter, you will base it on the ADGR Act because the administrative decision was made under an enactment. In other words, as far as the new regulations are concerned, they're considered an instrument under Section 3(1)(c) of the ADGR Act, and so therefore that vests jurisdiction with the federal court. And what is the ground for judicial review again here? So I'm looking at the ground now.
The legality of the minister's regulation.
Correct. So it seems that the minister's regulations are unlawful because they are contrary to the primary legislation. What is the other requirement as well? As far as judicial review is concerned, I'm looking now at the jurisdictional requirements for there to be judicial review. Can anyone just apply for judicial review? In other words, can the cousin of Sheldon Wang apply in his behalf for judicial review?
He has to have standing.
Very good. So very good. So there must be legal standing. Obviously, there is legal standing here because Sheldon Wang is affected. It's in relation to her son, who is a minor. very good standing. As far as remedies are concerned, the remedies are available under the ADJR Act. And obviously, this isn't what is considered an excluded decision under the ADJR Act, because remember that under the ADJR Act, there are certain administrative decisions which are excluded, such as the ones pertaining to national security or ones pertaining to the spying agencies and so on, or in relation to sensitive deliberations by the cabinet. And at the same time, this is a justiciable question. So I'm talking about, points about non-justiciability. So this is one of them. Very good. Question so far before we proceed to discussion question 3. Okay, I want to address just quickly the point raised earlier by Carl about mandamus. Okay, so we will recall, because I said I was going to go back to it, although we're going to be talking about mandamus in greater detail in week 10. So we will recall that under Section 75.5 of the Australian Commonwealth Constitution and a similar provision in Section 39B of the Judicial Act of 1903 Commonwealth, under the Judicial Act of 1903, Section 39B, the Federal Court of Australia has the power to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth. The thing about mandamus is that mandamus is only available when a particular person is entitled as a matter of right under the law to a specific action of the administrative decision maker. It has to be a matter of right. So in other words, when you have a situation where the decision maker, the administrative decision maker has to consider facts, examine if there might be the exercise of discretion, consider policy, and so on, in that case, it is difficult for anyone to say that that person has a matter of right over a specific administrative decision. So that's the constraint of mandamus. Are we clear so far? So it's not often that mandamus is available, because mandamus would only be, the writ of mandamus would only be available when the person seeking it is actually entitled to the particular administrative decision as a matter of right. And it can only be said that it is a matter of right when the jurisdictional facts are clearly in his favor and there is no room for the exercise of discretion or the application of policy. Because when there is, then we can say that the administrative decision can act in many ways. He could grant, he could not, it's possible he will not grant. And the actions of the administrative decision cannot be cured or attacked in a judicial review proceeding. Okay, so can we go, so let's go to discussion question 3. Discussion question 3 is probably important to a lot of you because it touches on a theme that is covered in quiz 3 pertaining to the exercise of discretion. So what I decided was that, following the suggestion of Lois, that it would be better for the quizzes not to close an hour before the tutorial. So we're now closing it, I think, on Monday of next week. Then by doing so, we give an opportunity to discuss the pertinent concepts that might be covered in the quiz. And in quiz 3, there is a question about the exercise of discretion, whether or not the exercise of discretion. So if we simplify it, the question is, can the exercise of discretion be the subject of judicial review? I mean, if we simplify it, okay? And let's look at that particular point by looking at discussion question 3. Now, can I ask somebody to read the question, and as that person does so, I'm just gonna quickly go to the toilet, if that's all right. So can I just get a volunteer to read the question, and then I'll come back in a minute. Can I get a volunteer to read question 3? Do I call on people there?
I'll read it, Manjo.
Who's gonna do it? Who's gonna do it?
I'll read it, Manjo.
Leonie, okay, go ahead.
All right. The Australian Federal Police AFT 1979 Commonwealth Act provides for the qualifications that individuals must possess in order to be employed in the Australian Federal Police. It also provides that the AFT Commissioner has the absolute discretion to impose other employment qualifications as he or she thinks fit. Pursuant to the Act, the AFP Commissioner issued regulations that required applicants for employment in the AFP to pass certain security requirements, including background checks on their ethnicity, religion, and social, ethnic, cultural, and family associations. The regulations also stated that the AFP Commissioner or his delegate had the discretion to waive the security requirements for employment applicants, including background checks on their ethnicity, religion, and social, ethnic, cultural, and family associations. Boris Kasanov, a Bosnian Serb immigrant and naturalised Australian citizen, applied for employment in the AFP in response to a job advertisement in its website. A month after his application, he received a letter informing him that his application had been declined because he failed to meet certain security requirements related to his association with the paramilitary group in Bosnia in the 1990s. Kasanov has approached you, a solicitor, for legal advice. He wants to know the likelihood of a federal court acting favourably on his application for judicial review of the decision of the AFP Commissioner, particularly relating to the failure of the AFP Commissioner or his delegate to waive the security requirements for employment applicants, including background checks on their ethnicity, religion, and social, ethnic, cultural, and family associations. What advice would you give him?
Thank you. It was interesting because when I prepared this question, which was last week, so the point I was raising was that, did you read that story today about the Bosnian war criminal who killed himself in the courtroom? You didn't read it?
Yes, I read that.
Oh, yeah.
That is crazy.
Yeah.
Yep, I read it.
Oh, you did? So, I mean, that war criminal was actually, I think, convicted. He drank poison in the courtroom. And it's just a coincidence that I actually asked it is crazy, Rob, but that happened. He drank poison. It's a good thing he didn't have a gun, but obviously you could bring in poison, and he killed himself in front of all the judges. Okay.
Yeah, it was an appeal that he had sought. The sentence was the same at the 20 years, although the crimes that he was found guilty of were reduced. And he was a Croat Bosnian, which is actually quite, I feel sorry for the Bosnians. He's a Croat Bosnian. On the other side were the Serbian Bosnians that were chopping at the country. The other side, the Bosnians themselves are really lucky that all of these people didn't succeed, But it was an appeal that he had lost.
Okay, thank you, Carl. So, what's the legal issue here? Let's begin by identifying the legal issue. What is the legal issue?
Whether or not his application for judicial review, whether or not he can make one.
Okay. So the thing about identifying the legal issue is that you avoid identifying a broad legal issue. Okay, so let me just do a bit of a background here. Identifying the legal issue is crucial because it helps you arrive at the proper conclusion or the proper advice which you should be giving to your client. So in other words, if you misidentify the legal issue, either because the legal issue is really wrong or it's too broad, then you're unlikely to arrive at a helpful conclusion. So, for example, if the legal issue was, as pointed out by Courtney here, whether or not judicial review is available, okay, to me that would be too broad. Because the moment you identify the legal issue, the next step you need to do is to identify the legal rules that inform on the legal issue. So if the question is, whether or not judicial review is available, then you have to go through those 5 jurisdictional requirements, right? About whether it's made under an enactment, whether or not there's legal standing, whether there's a ground for judicial review, whether there's a judicial review remedy, and whether or not it's an excluded decision. You go through those, but it doesn't really let you arrive at the proper advice.
Manjo, the way I see the legal issue here is the legality of not waiving the security requirements of the employment application,
Mm-hmm.
whether that was legal or not under the Act.
Okay. Mm-hmm.
So, just quickly, that's what
Okay.
I see as a legal issue.
Now, remember, my role here is to kind of provide feedback. We're almost 8 o'clock. Is that all right if we continue, if we go on? I mean, for those who need to go, you're actually just free to go. So the limitation with that legal issue, as you pointed out, Pida, is that you were saying that whether or not it is legal for the commissioner not to have waived the requirement. So if that is the legal issue, and we look for the rule, we're looking for rules where the court would have provided some guidance on when certain requirements should be waived. It doesn't give us much in terms of the legal rules we're looking for. Somebody has started talking here, Leonie and Ash. Can somebody expound on that, whether it's Leonie or Ash? You're in the right direction there. You're in the right direction, so can you tell us, Leonie? Go on. What is the legal issue here?
Well, I thought, and I'm only doing this as a stab in the dark, I thought maybe the fact that the absolute discretion that is provided for under the AFP Act, whether that's legal?
Yeah, very good. So that's the legal issue there. So the legal issue is whether or not the exercise of discretion or even the exercise of absolute discretion can be the subject of judicial review. Isn't that the legal question there? The legal issue? When you think about it, contrast this, I'm going to complicate it a bit just for us to see the distinction here. We need to remember that the purpose of merits review, okay, is for the tribunal to arrive at the correct or preferable decision and substitute its own decision for that of the original decision maker. When you speak of the preferable decision, it is based on the exercise of discretion. So, in other words, when you think about the legal issue as propounded by Leonie here, whether or not the exercise of absolute discretion can be the subject of judicial review, we begin to wonder, didn't we say that courts do not substitute their own decision for that of the decision maker? So how can it happen then that the courts might attempt to exercise the discretion vested in the decision maker if the courts cannot substitute its own decisions for that of the decision maker? So that is the legal issue. Can the courts review the legality of the exercise of discretion by the decision maker? Do we know? So are we clear with the legal issue there? So the legal issue is, how did Leonie say it? Can the exercise of absolute discretion be the subject of judicial review? Okay, can we see it there? I typed it in the PowerPoint slide. Can you see it? Okay, good. So would you agree that that is the legal issue? And it is an interesting question, isn't it? Do you agree? Very good. Okay, so that's the legal issue. Let's just focus on that. What do you think is the answer? What would you advise him if the question really, if the legal issue really is, can the exercise of absolute discretion by the AFP commissioner be the subject of judicial review? Because we thought that if it's the exercise of discretion, the courts cannot substitute its own decision or judgment for that of the decision maker. It doesn't make sense. So, what advice would you give him?
Manjo, it's Monique.
Monique, yes.
Sorry, I'm in my car listening, and I don't know whether this is going to work very well. But I just have another question. Where does the rights and legitimate expectations of people come into play with judicial review? Am I bringing something unrelated in there?
You're asking me if that question about legitimate expectations has a connection to this discussion question? None that I see, unless you want to elaborate on that.
I just, for some reason, stuck in my head in some of the reading was that where a decision is going to affect the rights, something, and legitimate expectations of somebody, that that's popped into my head. And my question is, well, does this person actually have a right to this job? Like, really, they don't have any rights. So
I see. Okay. I see what you mean, Monique. Good point. Very good point. So I see where Monique is coming from. So Monique is saying, so traditionally we know that judicial review is available, and this relates to the issue of standing, when an applicant can say that his right has been violated. Okay. Now, as Monique pointed out correctly, there is no right on the part of Boris Kasernov to be employed by the AFP, correct? He has no right. I mean, he's applying. But as Monique pointed out, wouldn't he have a legitimate expectation that he would be considered properly for employment under the Act? Wouldn't there be a legitimate expectation? So that would then be the basis for standing. So Monique, in other words, what Monique was doing was that before we even talk about the ground for review, which is whether or not the exercise of discretion can be the subject of judicial review, Monique was trying to bring us back to that question in the first place of, does Kasernov actually have standing? Because his rights obviously have not been violated, but at least can it be argued that he has a legitimate expectation to be properly considered under the job? So why don't we address that first? Very good point, Monique. So does Kasernov have standing in order to apply for judicial review? So that's, remember, there are 5 judicial requirements before judicial review can be there. And we look at it particularly from the viewpoint of legitimate expectation. What's the answer there? Would anyone know? So can you see the importance there of framing the legal issue properly? Because if you frame the legal issue properly, then you can identify the proper or the relevant legal rules. So let me answer that one, because my focus really for this exercise is about the exercise of discretion. And the answer is yes, Kasernov has a legitimate expectation that he will, his application will probably be considered under the AFP 1979 Commonwealth. And that is because when there is a law that is there, everyone has a legitimate expectation that that law will be applied fairly and equally to all. And that the one who's implementing the law cannot just disregard the law. That is a legitimate expectation, isn't it? So there's actually a case for that. I can't cite it right now, but there is a case for that, that even as far as hiring decisions are concerned, there is a legitimate expectation that an applicant for a job will be treated fairly under the particular law. So the answer is yes. Kasernov has legal standing. Very good, Monique, for raising that. Now, moving to that second legal issue, can the exercise of absolute discretion be the subject of judicial review? Volunteers? Okay. Don't, Ilionka. So Ilionka was raising the point about the Equal Opportunities Act. Don't bring in, particular statutes, because we could answer this particular question without reference to any particular statute. We can answer this on the basis of decisions by the High Court in terms of jurisprudence.
Manjo, could you argue that it was sorry.
Manjo, sorry, go on.
Yeah, Manjo, sorry. Can you argue that that it's the duty to practice said discretion?
Sorry, I got confused by Ilionka here. Sorry, I was looking at the point here by Ilionka.
Okay, so with regard to the duty imposed to the executive body by the legislation,
Yeah.
Would you say that there is a statutory duty to properly carry out said consideration by the Commissioner?
Very good. And so as a consequence, what's the significance of that statement that you've just made, Carl? What's the significance of that?
Well, they're fulfilling their requirements under the Act.
Okay, go on. So if that were so, can the fulfillment of their duties under the Act, can that be subject of judicial review, especially in relation to the exercise of discretion?
Yeah, but I mean, but it then gets clouded because this is now discretion, which is a statutory duty, like rather than just discretion, which is outside of what is the statutory duty.
I see what you mean. Okay. Okay.
And so can I ask a question?
Yeah.
If the AFP Act is dealing with people who are obviously working in security for Australia and protection and all that sort of stuff, isn't that under one of the executive rules, Section 61, that can't be reviewed judicially?
No. It's not one of the excluded decisions. No.
Okay.
You know, really, just briefly as an aside to this, with the other question though about the federal policeman that had been a little bit rough with the protester.
Yes.
Apart from there being the code of conduct and all the like, there's the one little section in the AFP Act where it says that if the commissioner is basically happy with that with the conduct by the policeman, then everything's okay.
Okay, very good. Thank you for that information, Carl. So going back to this question, would anyone know what the legal rule is? Can the exercise of absolute discretion by the administrative decision maker be the subject of judicial review? Should I answer that question now? Okay.
They're not courts of appeal. Is that what it comes back to? That they're not arbiters of correctness?
Very good. So if it's a question of the correctness of the exercise of judicial discretion, then that couldn't be the subject of judicial review because we're looking at legality. That's correct. But the exercise of discretion can actually be unlawful or contrary to law. And it can be unlawful or contrary to law, one, when it has been exercised unreasonably. So the unreasonable exercise of discretion can be the subject of judicial review. We will later on see the notion of Wensbury unreasonableness. And the particular case for this is Minister for Immigration and Citizenship versus Lee, where the High Court said that the reasonable exercise of discretionary power given by statute is actually expected and can be the subject of judicial review. So the case, which is in the textbook, is Minister for Immigration and Citizenship versus Lee, where the court said, following Associated Provincial Picture Houses Limited versus Wensbury Corporation, where the court said that discretion must be exercised reasonably. So where discretion is not exercised reasonably, judicial review is available. Okay. So we have a reflective question. Oh, there are too many. I have some reflective questions here. Does the exercise of discretion by an executive involve a factual or legal question? Typically, it is a factual question, but when there is an unreasonable exercise of discretion, it becomes a legal question. The other question is, how clear is the boundary between the legal and merits divine? I think that's the other question there. How clear is the boundary? So anyway, these are food for thought, right? So the boundary is not often clear-cut because questions that appear to involve facts can actually become a legal question. So such as, okay, say you, Holly, such as, what if the administrative decision maker made a decision on the basis of weak evidence? Is that subject to judicial review? Or what if the decision maker made a decision and there is no evidence? Is that a legal question or a factual question? These are questions you should really examine in future weeks. It's now 8:10. Any questions before we end tonight's session? Did we learn something tonight? Yep.
Yeah, when it comes down to evidence, that would be on probative value, wouldn't it?
Sorry, that would be what?
Based on probative value, if it was based on circumstantial evidence.
Okay, so we will later on see that when an administrative decision is made without evidence, in other words, there is no evidence, under the ADGR Act, that is a ground for judicial review. And also under common law, actually, that administrative decision makers, although there is no requirement about, that evidence, the evidentiary requirements in court are not obeyed or do not have to be adhered to by administrative decision makers, the rule is that there must still be evidence or basis for the decision maker to make a decision. If there is no evidence, as we later on see, in an administrative decision, then that decision becomes unlawful. And that is a ground for judicial review under Section 5 of the ADGR Act of 1977 Commonwealth. So in relation to the question, is judicial review available to Kassanov? The answer is yes. So going back to discussion question 3, judicial review would have been available to Kassanov, 1, because Kassanov had legal standing, and 2, there is a ground for judicial review in the sense that the exercise of the absolute discretion here by the AFP commissioner seems to be unreasonable. It is unreasonable because, I can't remember the facts now, because the mere fact alone that he was associated with a paramilitary group made him disqualified or something. Yeah. So I was looking at the, I'm looking at the legal principles. I can't remember the facts anymore. Okay, so any questions before we end tonight's session or any comments?
Manjo, it's Lois. It's not about tonight's content. It's about what I wrote on Facebook about wanting to just get some clarification on the assessment.
Go ahead, yes.
I just need to clarify. So we need to do 9 case notes. Is that correct?
If you are 3 in a group.
Yes. So, so for example, there's 3 in my group, me being one of the 3. So we pick 2 each, and then you allocate us 1. Is that still correct?
1 each. So there.
Yeah, that's what I mean. Sorry. Yes. So we pick 2 each. You allocate us 1 each.
That's right. Yes.
So we're doing 3 each.
Yes.
And 1 5-minute presentation for the 3 of us.
On one of those 9 cases.
1 5-minute presentation on one of those 9 cases by 1 person for our whole group.
That's right.
Okay. I just was, with all the different chats and things that had gone on, I just needed to really clarify what exactly
I'm actually happy you asked these questions because, sometimes I just assumed that what I said was clear and it turns out it wasn't clear. So I'm glad that these questions are being asked. Now, what if you're working for the presentation? Kirti, I'm not too sure. What do you mean by that? Or what if we're working alone for the presentation, you mean?
Yeah, sorry.
Then you either do your own live presentation during a tutorial session or you do a recording. And you need to submit the recording in Moodle. You have a choice.
Okay, and it's still 5 minutes?
It's still 5 minutes, yes. And remember, in the miking rubric, your ability to do your presentation within the time limit is marked 20%. For that. So you have to make sure it's within the time limit. Okay. Any questions? Any other questions? Comments?
Manjo, it's Emma.
Emma, yes.
Just to clarify, when we're doing our 5-minute presentation for our group, all groups have to present on week 5, or are you going to allocate a week that we have to present, or how does
I will allocate each student doing the presentation on his or her own, as well as the groups, their specific time slot when they do their presentation. Now, what I will try to do is to allocate to make you do the presentation that corresponds to the week that your case is relevant to.
Okay.
And that really won't happen if the topic is on week 3, right? But I mean, if I could, I will, as much as I could, I will make sure that the presentation is done in that week, which is being covered by the weekly topic.
Okay. And we have to have nominated the 2 cases that we choose by the end of this week. Is that correct?
Yes. Yes.
And we put them onto the Moodle case notes forum. Is that correct?
Yes, that's correct.
Okay. Thank you.
Thank you.
Sorry, Manjo, just one more question about the presentation. It's
Yeah.
Lois. Sorry, it's Lois.
Go ahead.
So the presentation, you will pick which case that we have to do the presentation on. Is that correct?
Sorry, I missed that. Can you repeat that for me?
The presentation, you're going to pick which case that we have to do that on.
No, you're going to be the one to choose the case.
Oh, okay.
Not me.
Okay, great. So we can do any of the 9 that we're doing in our group.
Yes.
Okay, thank you.
I also see there, Manjo, that we have the choice to upload it if we choose to, if we're not going to be able to do it during the shoots.
That's right.
Yeah. So we'll when do we need to advise you of that as well?
The deadline there is week 9.
Oh, yep. Okay, so we've got plenty of time.
If you're going to do a pre-recorded presentation, you need to upload it by week 9.
Yep, no problem. Cheers.
Others? So we're good? Okay. So thank you everyone for joining tonight's session, and I look forward to seeing you again next week. Oh, no, not next week. It's the vacations, the term break. So we'll relax next week. I'll see you in 2 weeks' time. Enjoy the break. See you soon. Bye.
Thanks, Manjo.
Thank you. Bye.